Abisamis, and welcome to the Basics,
which just might help you beat that speeding ticket.
So, for today's video, we are going to talk about the Discipline Standards, the Discipline Appeals and Arbitrations, and lastly, Garrity, Weingarten, and Loudermill rights, their basic definitions and other matters.
What is Discipline Standard?
The Commissioner for Public Sector Standards has issued a standard on discipline. The Discipline Standard sets out the minimum requirement of equity and probity that must be complied within the relation to the discipline process. In brief, the Discipline Standard requires that employees are dealt with equitably in accordance with principles of natural justice, appropriate confidentiality is observed, and that any sanctions imposed are appropriate.
What is Discipline Appeals and Arbitration?
Appeal. Employees who are disciplined have the right to file an appeal. Burdens of proof and appeals processes may differ depending on the category of employee.
Which just might help you beat that speeding
Employment
ticket.
arbitration refers to the resolution of workplace legal disputes by a person other than a judge or jury in court. Employment arbitration can be required by the terms of an agreement that covers arbitration only by an agreement that also spells out other terms of employment, such as pay and benefits. An agreement requiring arbitration may apply those other executive-level employees of workplace, particularly managers, supervisors, and administrative staffs. Arbitration is a commonly used form of alternative dispute resolution or ADR, while voluntary agreements to arbitration have been used in commercial disputes for many years. Today's employers are utilizing a different form of arbitration known as forced arbitration. Forced arbitration occurs when an employer conditions initial employment.
What is Garrity Rights?
Garrity rights protect public employees for being compelled to incriminate themselves during investigatory interviews conducted by their employers. This protection stems from the Fifth Amendment to the United States Constitution, which declares that the government cannot compel a person to be a witness against him or herself. For a public employee, the employee is the government itself. When questioned by their employer, they are being questioned by the government. Therefore, the Fifth Amendment applies to that interrogation if it is related to potentially criminal
Which just
conduct.
might help you beat that.
What is Weingarten Rights?
Weingarten rights. An employee may be represented by the union at an investigatory interview with his or her supervisor. When the employee reasonably believes that the interview may lead to a disciplinary action. Under the Supreme Court's Weingarten decision, when an investigatory interview occurs, the following rules apply. Rule number 1. The employee must make a clear request for union representation before or during the interview. The employee cannot be punished for making this request. Rule number 2. After the employee makes the request, the employer must choose from among 3 questions. The employer must grant the request and delay questioning until the union representative arrives and has a chance to consult privately with the employee, or deny the request and end the interview immediately or give the employee a choice of first, having the interview without representation, or second, ending the interview. Rule number 3. If the supervisor denies the request for union representation and continues to ask questions, he or she commits an unfair labor practice and the employee has the right to refuse to answer. The supervisor cannot discipline the employee for such
What is Loudermill rights?
Loudermill rights. The term Loudermill rights refers to those employee rights which state that most public employees have a property right in their jobs. Pursuant to such rights, an employee cannot be dismissed without due process. It is also give the employees a right to pre-termination hearing that gives them the opportunity to present their part